Hey guys, so good afternoon. So, this is like the follow up video on the red flags video that we did the other day. So, I had said if we get 20 likes, that I'd do an explanation video. So, on TikTok, we've gotten 18 likes, and on Instagram, we've gotten something like 9. So, as quickly as I can, the 6 red flags to look out for and avoid when purchasing property in Jamaica, right? So the first one was there is no registered title, and that one is very straightforward. You should not be purchasing property that don't have a registered title. That's straightforward. There's no registered certificate of title. If you do a search with the National Land Agency, you're not going to find a title for the property. And I should probably go a step further, because like as of late, one of the popular ones that we tend to be getting is like, oh, people are doing subdivisions but they don't have any splinter titles for them yet, and so there's essentially a title for the big piece of land, but the little piece of land that you're buying, it don't have no title yet. And that one is not like a definite absolutely no. It's just, if you're going to do that and there's no splinter title for the matter yet, just recognize that it's more than likely something that's going to take a little while. Like if it's one that's waiting on subdivision, for instance, unfortunately in Jamaica that is a 1 year 2 year wait. And you should not be investing further in the property, so you shouldn't be building on the property when you are not reassured a title. It means if you wanted to give it to your child, you're going to have a problem. If you wanted to borrow a loan against it, you're going to have a problem. So first red flag, if there's no registered certificate of title for the piece of land that you're buying, don't do it. I have one, for instance, right now where it's a subdivision, so there's a title for the big piece of land but no title for the little piece of land or the lot that my client is purchasing. She really wanted it. I told her upfront, this is going to take at least 2 years, and then in addition to that, the vendor's attorney is a reputable counsel, so willing to do it, but you have to know from the outset that it's going to take long. As long as you are willing to wait, then fine. But recognize that technically speaking, for that property, there is a certificate of title for the whole, but not for the lot that you want. So, in addition to not being able to leave the property to your loved ones, your children, your husband, your wife, your mother, your sister, your father, whoever it is you would want to leave it to, if the property does not have a certificate of title, I've already said, you won't be able to get a mortgage, right? But just other reasons why it's a red flag. So the fact that there's no certificate of title, the number one reason why you want a certificate of title is because it is the proof of who is the owner of the property, right? So without a certificate of title, anybody trying to sell you that property can't actually prove that they own the property, right? And Jamaicans have this way of looking at the valuation role, or who pay the property taxes, like that is going to prove the owner of the owner of the property. Not so, okay? And people also tend to think that if they pay enough of the property taxes, that alone is going to get you ownership of the property. That's not how it works, okay? So yeah, back to why it's a red flag. So they don't have a certificate of title, it means they can't prove that they own the property, right? So in terms of from a legal standpoint, if you happen to pay your money to somebody who does not own the property, the only thing you have that you can get back is the money that you've paid them. And let's be really honest, right? If somebody's trying to sell you property that they do not own, it is because they are in dire need of those funds, and it means the minute you give them your money, it is going to disappear, which means when you carry them to court, when you have to pay your expensive lawyer fee and spend day after day after day in court for year after year after year to try and get back your money, you're not going to have anything to get back. So you will have wasted your time, your money, and your effort. So don't do it. On the flip side, we're still on this red flag of why you shouldn't buy property that doesn't have a certificate of title, right? On the flip side, say somehow they do have a connection to the land without being able to prove that it is theirs or having a certificate of title, right? And you go and you build upon the land. This is the alternative to not being able to get back your money. So you build on the land and say there is a certificate of title for the property, it's just not in the name of the person who you gave your money to, and you somehow manage to build on the land and stay there for 12 years in open undisturbed possession of the property. Yeah, so there are 3 scenarios. There is a registered title, it's just not registered title in the name of the person who you purchased the land from, and then in that case, assuming that that registered title is in an individual's name, you're going to be able, after 12 years, if nobody don't come run you off the land or beat you up to get you off the land, then you might be able to apply for adverse possession. But say it is completely unregistered land, it is unregistered land that does belong to an individual, then you're going to have to wait 30 years. And God forbid that it is unregistered land that belongs to the government, or better yet, even if it is registered land that belongs to the government, that's a 60-year wait. You, your children, and God alone, He knows who else is going to have to, you're going to be on that land for at least 60 years in open undisturbed possession in order to get it. No, most people can't budget for what is going to happen tomorrow. Yes, you don't know if you're still going to be alive tomorrow. You don't know if your children are going to be alive tomorrow. So I think it is a better use of your time and your effort and your energy and your money for you to buy registered property with a registered certificate of title. Those transactions are usually complete anywhere between 4 months and 6 months. If you're lucky and you have cash, you might be able for the transaction to be complete in 60 days. If you're unfortunate, you're purchasing with a mortgage and there are issues with the transaction might take a year. But that's a year as opposed to 12 years and 30 years and 60 years, or not being able to get back your money in at all. So that is why it is a red flag to purchase property that does not have a registered certificate of title. So red flag number 2 is the land being sold is family land. What do I mean by family land? So for instance, let me see, thinking of somebody who called me recently for a consultation. He purchased all right, I can think of at least 2 people, so let me go with the she first. There's one client that I had have still actually. So she purchased land from the father. The owner of the property, or the person who said he's the owner of the property, is a man, and he actually owns it in connection with his son. So the 2 of them own it together, and I guess the man lived on the property. She didn't recognize that it was also partially owned by the son. So having purchased the property from the father passes away, only to hear, so this is unregistered, it's not unregistered land, by the way, it is a land settlement matter in Portland. So it's still in the name of the Commissioner of Lands, but formally speaking, the National Land Agency recognizes that the property belongs to somebody, right? Whether they've sold it, gifted it, whatever it is, the land belongs to the father and the peer. She purchased it from the father, didn't know that the son had an interest. Have this next one client contacted me. I don't remember the circumstances of that. It was so much. It's always so much. You see, when you're talking about family land, when you're trying to figure out who owned the property is always a problem, right? So you buy from Jenny Joe, only to find out that Mass Joe is actually the one who owns it. So family land is usually you are buying from as I said, Jenny Joe, but Jenny Joe never buy no land. Jenny Joe does not have a certificate of title in her name. Jenny Joe come see her family upon the land and decide say because she lived there her entire life, she can sell the land. Unfortunately, you cannot sell what you do not own, and I'm going to say in a very technical sense. Technical, I don't know if it's technical, but in the best sense of the word, the best way to know that land is owned by somebody in Jamaica is by having a certificate of title. So if somebody don't have a certificate of title in their name, as far as you are concerned, they do not own it and they cannot sell it to you. Some time ago, I remember I had clients where so the client we represented had sold to the person next door. The person next door built up 3-story sexy house on the land beside her, right? But when she sold the property to them, she didn't own it. The property had initially been owned by her grandmother. I don't even remember how her grandmother came to own it, but it wasn't, no, she didn't purchase the land, but she came on the land somehow, and she had been there in excess of 30 years. So over time, we were eventually able to get a title and help them sort it out. And when I say over time, I mean I have now been called to the bar for like in excess of 10 years. Anyway, and that's a matter that my firm at the time would have gotten probably within 2 years of me being called to the bar, and it's only been resolved like 2 years ago. So probably 8 years it took to sort it out after you buy the land, and you have to pay, because you know the person who sell the land who don't really own the land never has the money, right? So you are going to have to pay to figure out all of the paperwork, right? So don't bother think say you get a deal when you buy land for $1 million that you know so don't belong to the person. From you hear them say, oh, you know it's my grandmother owned the land, or you know say it's my great grand uncle, father, sister, uncle Frog owned the land, but I've been living there forever. Don't do it. Not a good idea. Usually anytime you get into that kind of situation, you're going to hear that, for instance, the person who passed away that owned the land had 10 pitney, and all 10 of the pitney, that is provided there was not a wife or a spouse, or a wife or a husband or a spouse, same difference, but there wasn't any of those people, so them have 10 children, and the 10 children are all entitled to a share in the land, and their share in the land essentially trumps your purchase of it. Not necessarily true, but the court process that you're going to have to go through to sort out all of that, it is not worth your time and your money. Like, find registered land with clean and clear title to invest your money. When you work your hard-earned money and you are going to invest so that you can give something to your children, do not spend it on land that don't have no clear title, that is going to take 10 years to sort out. It is not, well, me can only talk for me. I wouldn't spend my money that way, and I wouldn't advise my clients to spend their money that way. So that's family land. Family land is land that is tied up in family business that somebody can say very clearly, I own it. So when you go to buy it from them, you either know or they either know that, hey, I'm inheriting this from my grandmother. You know, my mother has lived on this property for 30 years, but she never really buy it. My mother got it from my grandmother, and my grandmother had 13 children. Once you start hear those things, run. Literally, you see how I was running up and down in the red flags video? Run. Not worth the time and the money to sort it out. Like, if you're unfortunate enough that you get involved in a situation like that, and you know, you don't have your hand in a lion mouth or a dog mouth, now remember what the saying say, you have to take time, draw it out. Completely different situation, but you know in advance that it is family land and it is going to be problem, don't do it. Run in the other direction. So number 3 was buildings on the property have been built right up to the road or boundary wall. Listen, this is the biggest red flag in St. Catherine, for instance. Whenever you go to look at a property and you see literally the wall for the building or the house literally is on the sidewalk or literally is attached somehow to the other building, and we're not talking about a townhouse kind of situation, but they're literally onto the next person boundary wall, best believe that when you do your survey as ID report, there's going to be a problem. The boundaries are not going to be in order. Somebody is going to have to pay to apply to the Supreme Court to modify some restrictive covenants so that you can get a mortgage on the property if that's what you're looking to do, like most people are looking to buy using a mortgage. And in order to do that, you have to have clear title, which means not having any boundary encroachments or what's that now, encroachments or breaches of restrictive covenants. Yeah, and then another issue that comes up, apart from having to pay to make that application to the Supreme Court, a lot of cases like the vendor will do that, but then there are cases where the vendor will tell you, no, I am not going to do it. So if the purchaser doesn't do it, it's not going to be an option for it's not going to be an option for you to purchase using a mortgage unless as the purchaser you either have the money to pay for it, or you're willing to pay for it, or the vendor is willing to fix it. Yes, so that's that one. Oh, I'm sorry, I was also going to talk about the ones where, for instance, you can see that the property coming over into the sidewalk or onto the road. So the next major issue that can happen is that when you do the survey ID report and you find out that it's encroaching, you might have to knock off parts of the building. Some cases it's not so bad. You might only have to, like, I've had eaves, so that the tip of a roof has been a problem before, and we're able to just go in and take down the board and take down the zinc and it's fixed and it's okay. We've had fences, like what kind of fence you call that now, like barbed wire fence, you know, the little metal fences. Those have been problems, and you can just go and pull them out, and if it has like a little low wall, concrete wall, you knock out the wall and you don't have a problem. But then you have other situations that come up where the boundary line is going straight through a room. If that is the case, that is problems, right? You're going to have to knock down a whole part of a house in order to get this property to purchase. So don't do it. See the red flag and heed it. Like, I know it look pretty and inside is just everything you ever dreamed of, but unless you have extra money put down, like a little million, a little 2 million to sort it out, leave it alone. Find something else to fall in love with. Yes, so that's that. The vendor wants you, so this was red flag number 4. The vendor wants you to pay more than a 10% deposit on the property up front. So I don't know if it is a lost part of the law. I say that because I have seen, so all right, let me not be so I don't know what I'm being, but you have attorneys who have come up with unique ways around the law, in one sense, in terms of they will say that you're paying a 10% deposit and say you're paying 10% further payments, because by right and by law your deposit is supposed to be no more than 10%. So when you're paying more than the 10%, you're actually breaching a law. But then the law is interesting because as much as your deposit is supposed to be 10%, you have 100% to pay, right? And the law wouldn't stop you from making part payments on the property. So how it is recorded is that you're paying 10% as a deposit, and then another 10%, or however much it is that you have agreed to pay in a further payment, you're paying that as a further payment as opposed to as a deposit, and that's completely acceptable and allowable in law. Yes, but as a purchaser, anytime you see any vendor asking you to pay more than 10% upfront, it should raise a red flag for you, right? So procedurally, not even procedurally, legally speaking, the vendor does not have access to the funds until the end of the sale. They are not allowed to get any part of the proceeds of the sale until the sale is complete. So the fact that they're asking for more upfront, and this isn't me making assumptions here, like I can't speak about nobody, I'm not casting up aspersions on anybody, but the fact that they're asking for more upfront suggests that the vendor wants to be able to access those funds before the end of the sale, which should not be allowed. And I'll go this far. I have seen some agreements for sale where it is explicitly said that the purchaser is permitting the vendor's attorney to disburse the further payment to the vendor for whatever reason. Usually it's a subdivision kind of situation and the vendor needs to use that money, whether it is to help to finish building the house, whether it is to put in the infrastructure, so the road, the pipes for the water, the poles for the electricity, all that lovely stuff, right? And I'll give you this also. Established developers don't need to ask for that. They already have their capital in order and they already are going to put those things in place, and they're going to, once they've done that, they're gonna charge you accordingly and make back their money times 10. So you're only getting this kind of a request from people who do not have the resources to really finish the development that they've started. And what is going to end up happening, and unfortunately what happens in a lot of situations, is that after you have allowed them to access these funds, for whatever reason they don't have enough money and they still cannot complete the subdivision, they still cannot complete the development, so your funds can't get it back. Yes? So there's one matter, mind you, not sending nobody to report nobody to GLC here, no, but I recall in recent times there was actually a GLC judgment. So this is, GLC is basically the body that clients can report attorneys to if they're dissatisfied. So there was a situation where a person, so purchasers had this kind of agreement or arrangement with the vendor that, you know, they would pay extra money up front, the vendor would get the money and be able to use it, and, you know, there was an indemnity clause in it ensuring that they couldn't come against the vendor's attorney in the event that the vendor used the money and they cannot get it back. And so said, so done, as is to be expected in those situations. Development cannot be finished because the vendor does not have enough money to finish it, and they want back their money. They didn't give you the money to finish the development thinking that the development wasn't going to be complete. So of course, when the development is not complete, they ask back for their money, and the vendor's attorney goes, oh, but you signed a document, you signed the agreement for sale to say, hey, you know, I'm indemnifying you against any loss that is suffered in the event the vendor is unable to give me back my money in the event of a cancellation. And the GLC said, that's nice. You were the only attorney, so the purchasers were unrepresented. You were the only attorney in the transaction, and you should have realized that you have a greater duty to the purchasers in those situations to ensure that they can get back their money if the sale is cancelled. So guess what? Since you didn't protect them, not your client, you know, but since you didn't protect them, you must pay them back. So yours truly, me, you're not going to see me in that situation, and I will advise every single person that comes to me that wants to, they've been asked to pay extra money over and above 10%, or they are being told that they should allow the vendor, for instance, to access the money before the purchase is complete so that the development can be complete. I will tell every last one of them, it is not a good idea. Don't do it. If the development is not complete, you will lose your money, and unfortunately it happens too often. So don't do it. If you're being asked to pay more than 10% upfront, look at it as a red flag. So the next situation that I have said is a red flag is the vendor does not have an attorney. If I did have two more red flags, I would have waved them right here. So red flag, red flag, red flag, red flag, red flag, extra red flags. Like, so ideally in any transaction, that involves land, the vendor must have an attorney, the purchaser must have an attorney. Both people must be represented, because the other person's attorney is not your attorney at the end of the day. Anytime a conflict comes up between the vendor and the purchaser, depending on whose attorney you are, your duty of care is to your client, not to the other person. So even if I was on the other side, I would have advised you differently. I'm representing the vendor. I'm going to tell you what is in the vendor's best interest. I'm going to tell the vendor what is in the vendor's best interest. I'm not going to concern like over and above, not going over and above for you, because my duty of care is not for you if it's not to you if you are not my client, right? And I think I am among the most generous people you'll find in that regard. So if me I say so. Anyway, the vendor does not have an attorney. That's not a transaction you want to be a part of. I have in the past very curious matters and very concerning matters where, for instance, the purchaser will pay for the entire transaction. Yes, it's a very risky kind of situation, unless, for instance, the vendor is going to give their title up front to the purchase attorney, which is the risk involved in something like that for an attorney. Like for me, I wouldn't do it, because I don't want the vendor to turn around and say that I've done something wrong with their property. Yes, so I wouldn't advise it any at all. And then as the purchaser, if the vendor has no attorney, where's that transaction going? Like, it's going nowhere. It's not a good idea. And then there are some circumstances, for instance, like where there is a mortgage over the property. Again, where is that transaction going? Like, where is it going? If anybody in that transaction needs a lawyer, it is the vendor. Yes? Especially where there's a mortgage on the property. If there's no mortgage, I suppose it can be worked out, but it's still risky, especially for the attorney. Even if it's not as risky for the clients, very risky for the attorney, because as the attorney, you're running the risk that the vendor, say you act for the purchasers and the vendor is willing to give you their title up front so you can secure your client's interest as the purchasers. You're running the risk that the vendor will later say that you have done something that is not in their best interest, that you somehow compromised their best interest. So it is not ideal. If the vendor does not have an attorney and is unwilling to get an attorney, don't do it. The other thing I would say, I suppose, how it could be worked out is if you're the purchaser and you have money, you can say, I will pay an attorney for you. I don't know. Yeah. So these things happen. I'm sure that there are lawyers who perhaps don't mind walking on the wild side a little bit more than I do. But they're not ideal, and unfortunately in too many cases they don't work out. So me not run them risk there, you shouldn't run them risk there. Yes. And finally, red flag number 6, the vendor wants you to use their attorney or says you do not need an attorney at all. So you've seen our coach conversation with Amoya. You've seen the red flags video. You already heard me say it. Listen, at the end of the day, the other person's attorney is not your attorney. The bank's attorney is not your, so say you're getting a mortgage, the bank's attorney is not your attorney. The vendor's attorney is not your attorney. People will be willing to assist you to an extent, for sure, because everybody is interested and invested in having the transaction complete. But if and when interests arise that conflict with their own interests, or arise that conflict with the interests of their clients, then their duty of care is to the person who has paid their retainer fee. So you decide if you want to be in a situation where a conflict arises and you are the only one who is left unrepresented and with your best interest not being protected. Yes, So I didn't expect this video to take this long. I hope it has been useful and beneficial, and I'll probably see if I can split it up into parts so that you can get more of it. But yep, those are the 6 red flags that you should be looking out for if you're a purchaser looking to purchase land in Jamaica. Toodaloo.